I was asked in the comment section to do comments on the black belt barrister, and additionally, someone else had also asked to maybe do a video on citizenry. So let's see if I can combine those together. The black belt barrister is speaking to, as we are learning through this English law series, a matter of equity which originates from a second level use to land that is divided through a trust instrument from those common law interests in law. He is not speaking to law. In fact, I would be surprised even if he knew what law was. Now, sure, he's going to use the word law, but what law would be, what law, being a barrister, are you subjugated to? And we just mentioned it by what I just said. So for me to get in and start discussing the issues with how he is speaking to acts of parliament and how citizenry is now relegated to perform certain duties and obligations according to matters such as the hot topic of the council tax, he can speak to it because, again, you are swimming within that cesspool. Now, I call it cesspool because the remedy is more or less you then acting as a servant. So then let's move in right into citizenry. What does citizenry have rights to? Well, they only have rights to affect rules of action over those interests in a third level of use to land, okay, to which Parliament then, having the second level of use, administrates over through the concept of waste. They are the accounting firm, per se, that then is granted the right to use the land through immunity by coming in under a trust instrument and be regulated through that trust division. So they're not directly related through common law. They are relegated to those interests that are of a nature of a second level of use to land, which then allows them, like a tenancy, but it's not a tenancy because we're not dealing with a life interest. We're dealing with a proprietorship, so a perpetuity instrument that is giving the been granted the right to then take care of that land and create rules over that land through the waste that's created while it's in use, and in the same manner that's receiving the carte blanche, if you will, ability to administrate over that land without the scrutiny which was predominant pre-1925, where everything generally had to go through the courts before the land could be used, and everything was measured against waste, and then there was always asking permission to then be able to effect rights of that waste through the vehicle of those lords spiritual. Well, I won't even say spiritual in as much, but those of temporal. So instead of going through that process, they've just divided that interest through a trust and allowed the trust to be responsible and trustees to manage the profits and so forth derived. Trustees don't have a right to to take care of the land in the same mannerism as citizenry is, because if you gave them full carte blanche, no, I'm using that word twice now, but anyway, giving them full rights to not only be managing the profits of that interest that's being used through government, but then also being with the obligation to then take care of the land itself and what goes on, and what you can do or what you can't do, would give too much power to the trustees, and then everybody and the beneficiary would just remain an annuitant, and with only getting a certain amount of money, whatever that value is, according to the estate interest, a proportionate share, that um, would give no power to the beneficiary at all as executor. He would just receive as an annuitant and saying, tell me what to do and just give me my money. It just would be too much power in the hands of trustees. Although, as I've spoke about before, being that we're in a third level of use to land, moving into the fourth, essentially all the power is moving into trustees, and that's why they're, well, you know what, I'm just going to use the word genocidally removing those those rights to land and those obligations so that it doesn't, so it can have full control without having, you know, uh, a babysitting, if you will, okay, for lack of a better word. I've had some other words run through my hand, but I'm thinking of using the word without having to babysit quasi-trustees. They can just now run the land, but run it in a manner that, hey, there's no, those quasi-trustees no longer have property interest. The citizen base doesn't have property interest anymore. So we can allow the land to just then, through waste, which is now going to be the dissolution of the property through, the wooden buildings and such being, taken over by forest, that they'll just let it run as such, and only be responsible for that relationship, as opposed to being using the quasi-trustees, the citizenry, to be responsible, because they're not going to be as many, and they'll be moved into 50-minute cities. So 50-minute cities are now going to be relegated by a new constitution, a new legislation, and new laws. Okay, I probably hope I didn't make that too complicated, but it's trying to develop the, essentially, it is you personally making the agreements that is allowing Parliament to act, and also the union, the barristers and lawyers, to act based on only that interest, which is the second level of interest to land, and negotiating that agreement between the second and third level, being at citizenry. At that point, you can stop it. I mean, it's like the peacekeepers just did another video against the black belt barrister, who's essentially saying, you got to follow legislation because that's an act of law. And then the barrister, and then the peacekeepers arguing that fact that no, Parliament doesn't have a right to the law. The people have a right to affect the law over Parliament. Well, no, both are wrong. Not predominantly wrong within the interest they're speaking to, which is an equitable interest. But then when they, not the barrister, I'm not saying he's doing it, because I didn't get into involving, I don't need to watch any of his videos to know where he's coming from. But when peacekeepers are using the law and saying, well, people have the right to affect the law, well, what is the law? Well, peacekeepers are not speaking to the law, they're speaking to equity. And then using it as law, and then bringing in maxims of law, like ignorance of law is no excuse for being a violation, that has nothing to do with equity. That's why you can't even use that in courts. Parliament is granted an agreement. They only have the rights to administrate over that agreement. So are they affecting the agreement? Are they doing their job? Well, essentially, yes, they are doing the job right now by removing the third level of interest to land, by dissolving the trust for sale, which was always going to be dissolved, and I just surmise this a 99-year lease going to end in 2024, because I looked at the law of Land and Property Acts, the settlement of 1925, and I just see how everything's getting pushed into 50-minute cities to create new titles, to which then creates a new trust instrument, to which then creates the value of the rights of the trustees to now not only control the profits derived from the use of the land, but they're also now going to control the obligation to take care of the land. So they're just removing the ability of citizenry, the quasi-trustees, and more or less we'll just call it they're fired, or their term is over, and there goes those property rights. Okay, that is what's happening. We got to be That's the problem with, as I've said more than enough times, the problem with the sovereign and freedom movement. They don't know what law is, and they don't know what equity is, and then they commingle both, and therefore automatically get thrown into the agreement that's regulated by Parliament, and looking for contracts and trust and remedies within that vehicle. Well, hey, I'm 100% responsible. Meaning, being that I'm 100% responsible, I'm not under Parliament. It's like being under servitude of a plantation, of a settlement of that plantation. You're relegated to those rules. All right, you're you have to be because you're in that plantation. Well, I'm not in the plantation, nor or you, if you're dealing with the people that's subject to the common law, the English common law, to which is also your birthright. So if you have a birthright of English law, that means all of it. Where do you want to stand in that power? Peacekeepers and everyone else, I'll guarantee, are speaking to equitable interest. The barrister, black belt barrister, is speaking to that equitable interest, and he doesn't know what law is. He won't even speak to me, and I guarantee he won't. But I don't need to speak to him because he's saying, "Hey, like I, have reverted to that. I speak only the law." He's speaking to those legal interests, to that agreement that Parliament has a right to administrate over. He's correct. Okay, he's not doing anything wrong, and in a sense that he can't do anything wrong against the agreement that he's made with the union to affect those interests that are granted to government. Okay, but that interest is moving to the fourth level. Does he know that? No, he doesn't. He's just going to fight because that's his contract, that's his agreement, and he should while he's got license. That's what he. So when you speak, when peacekeepers comes in and speaks to those interests and saying, who the hell is barrister speaking about? It's because peacekeepers don't know the difference between law and equity, and now they're trying to use law arguments to overreach what the barrister is saying, when in fact the barrister is is actually speaking to those agreements that he has license to speak to, and peacekeepers is commingling that interest and making it look like the barrister doesn't know what he's speaking about, when in fact the peacekeepers doesn't know what they're speaking about because they don't know what law is and what equity is. With that, I hope I also incorporated better understanding citizenry, because that, if you citizenry essentially under government, and what does government have a right to grant to, which is a second level use to land. That's the consideration, to which the citizen is indirectly, tacitly agreeing to that by holding and purchasing a land interest, which is just in his property interest under government, to which the government is saying, here, you can buy this. You can buy the right to use that land. You don't own it. There's no lodium. You can never have a lodium title under English law. And the barrister will even get to that point. You can't find it in any of his works because you can't have a lodium title. Okay, so if you want to speak a lodium, you got to get out of English law altogether, which is before English law, which is essentially dominion rights. That is after. Again, that's never negotiated. That's not the problem. Parliament or monarchy is not speaking to your dominion rights. They have no rights to it. Okay, but they only have rights to those land interests associated with the law that the monarchy has settled, or has a right under the settlement to hold that interest when you want to vest that interest, that legal state interest, in the common law. Don't deal with Parliament. It's just a waste of time. Okay? All right, with that, let's just see what the hell falls out of the tree. I think I've shaken that tree, the tree of knowledge, enough times here that we can get our heads around the fact that we are doing everything um, by our own actions, and those actions, when we brought to court, are then is how court has to deal with you. Court's not doing anything except what you give to them. And if you went to court and you want to deal with those matters, you're going to just create rules of, you're just going to first substantiate laws of equity, which is meaning you are agreeing to a second level use to land, and if you're a citizen, a third level. God bless. Have fun.